this computer and try to do it. So I'd like to thank Jodie and Laura for joining us today. We'll record the session and I'll share it, so you don't need to take notes. Jodie's been helping from a legal perspective with the ABRS for many years, and is currently helping us now. So thank you, Jodie and Laura. So over to you.
Hi, everyone. Well, look, thank you, and apologies for my mild technological weakness just exposed. I'm definitely a lawyer for the right reasons, because I shouldn't be in charge of IT. We plan, me and my colleague Laura, we're both lawyers, obviously, but we also both have a lot of equestrian involvement, and we'll talk more about it as we go through. But really, you know, sort of we're here to I suppose have a short walk through various things that we think you guys as ABRS riding schools should be thinking about, issues you should be aware of, things that, you know, sort of might give you pause for thought, or you might sit there and be like, no, it's fine, we've got all this, we're totally under control, which is great. But you know, the idea is really to introduce you, to give you some food for thought, and also to make you realize that actually we're available and we're able to help, and we're not terrifying people who live in glass towers and wear suits and, you know, sort of slam gavels on judges' desks all day. That's really not who we are and what we do. So that's really the aim of today. Just as a housekeeping point, obviously we're happy to take questions if they're sort of relatively general. The only thing is, obviously, from a regulatory and insurance perspective, none of you are actually our clients, so we can't give any specific advice. So if you do have a sort of general query point, that's absolutely fine. We'll try and respond to it. But if it's anything more specific, then we're very, very happy for you to approach us directly. And our contact details are on the last slide, so that's all there. So who are we? I'm Jodie. I'm a lawyer. I trained in city firms and spent 10-15 years there before developing an equine law practice. I'm also a rider. For my sins, I ride up to 4-star level eventing and international show jumping level. And I'm also now living in Normandy in France, where we've got a small stud farm and breeding program and producing young horses. So I see horses and I see the equine industry from every possible angle. I was in the UK up until 2 years ago, where I used to run a livery yard and run training, and I'm still very much from a legal perspective. I'm working with governing bodies, I'm working with regulators, and I'm working with an awful lot of private participants in the industry, just to really try and help everyone, I suppose, put equine industry onto a more commercial and a more secure footing. My practice area, just so we're absolutely clear, is commercial contracts and corporate. So I can help with commercial contracts. I can help with all things around sort of websites and data and privacy and anything basically that you sign, I can look at, and corporate advice, so setting up companies and structuring things. What I don't do, and neither Laura nor I do at the moment, is litigate. So we're not the people to come to if you're going to have a fight. And also we don't have specialist property advice. So again, if there's a specialist lease type arrangement issue, we can help in that I do have some very good contacts who are very good with this, but it's not our sort of area of expertise. Laura, do you want to introduce yourself?
I will, yeah. So I'm Laura Hillier. I'm also, as Jodie says, a corporate and commercial lawyer, and my practice is primarily in helping startup companies, so people who have a great business idea and need some help sort of getting on their feet and starting a company and supporting them as they grow. I also ill-advisedly took on a former riding school, actually, that had been an established riding school for sort of 40 or 50 years in our local area, that happened to be very near to my house and closed down a few years ago. And I've spent the last 10 years trying to work out how on earth you make ends meet when you're running an equestrian facility. So it's no longer a riding school. I take my hat off to all of you who managed to run one, because the bureaucracy defeated me. So I now run it as a livery yard and a little bit of breeding on the side as well, and have yet to turn a profit, but I sort of enjoy it in the process. My practice is very similar to Jodie in the commercial contracts, corporate support, that sort of thing. But as Jodie said, we have a good network of expertise on property, on employment, on tax, on the kind of thornier, more specialist issues that come up. So whilst we can't deal with those, we can help with them.
Yeah, and really, I suppose a little bit about Aria Grace Equine Law. I joined Aria Grace in the beginning of this year to really put heads together with Laura and with the team at Aria Grace. Aria Grace is a sort of fairly innovative law firm in that it's a CIC, which some of you will recognise the business structure. So effectively, when you use Aria Grace, when you use us as advisors, your hard-earned money is not being spent on us sort of investing in glass towers and receptionists and plastic flowers and coffee machines. We are an entirely remote firm. All the lawyers are specialists in their area and very experienced, and we all work remotely in wherever we happen to be. And of the work we do, of the firm's actual profits, it's the CIC. So every year, both the Aria Grace Law's profits are donated to charities of various descriptions, and equally within the equine law, we've actually made a commitment this year that we're donating 5% of all of our revenues to spinal research. If you haven't come across spinal research, it's an absolutely amazing charity, which is dedicated to developing actual solutions for the problems of paralysis in the UK. And obviously it's a very salient issue for riders and for anyone involved in equine, but equally people become paralyzed because they fall down the stairs and trip and land a bit funny. But this is a charity that's very dedicated to finding solutions as opposed to just palliative care. So that's one quite close to our heart, and one that we're working hard to try and make sure that they do well out of this. And in terms of what we do at Aria Grace Equine Law, we do everything. So we're corporate, we're commercial advisors, we work with governing bodies, we work with riders, owners, stakeholders, commercial businesses, luxury brands, saddlery brands, tack brands, feed brands. We work with PR agencies, we work as sponsors, we work also very much with riding schools and with yard managers and with livery yards and with people just trying to, in this world of sort of economic uncertainty and life developing, just try and sort of help you and guide you in securing your business effectively, and then allowing it to sort of flourish with some slightly more secure foundations. So that's what we do. So how can we help? What are we going to run through today? I think that's an extensive intro. So we've got 7 topics that we thought of that might be the most useful things to cover. And given that it's 7 topics and it's a quick lunch break for all of you, we're going to kind of whistle stop through them a little bit on a high level basis. But these are all things that, we in our experience think you guys should be thinking about on a day-to-day basis, or when you have a business review moment. These are things which we think would help secure your business and also, sort of give you things to think about to improve it from a perspective of increasing compliance and increasingly being able to say, we run a legitimate, very, sort of organized business. So terms and conditions, that we'll start with those in a minute. Cancellation rights, disclaimers, livery arrangements, because wherever they're horses, they're liveries. Employment contracts, which are always important. Business structuring, which I hope you don't fall asleep in, because actually that's also key, again, to limitation of liability. And one that we really thought might be quite useful as well is data management, because you guys actually probably unwittingly receive a huge amount of personal data, whether it's images or names and phone numbers, etc., and it's understanding how you deal with all that and what the legal requirements are on you. So Laura, would you like to talk us through why should you invest in legal support? We appreciate, time is tight, money is tight. Why bother?
Sure. And I'll try not to make it too much of a sales pitch. So I suppose when I look at this slide, I always think of my grandma, who's one of her many adages was a stitch in time saves 9. And that's sort of always my guidance to people when I'm talking about why it's worth investing in legal support up front. And whilst I understand all too well the cost pressures that people are under running riding schools and livery yards, and finding extra money to pay lawyers in the beginning probably doesn't feel like a priority. But it is absolutely my experience in all industries, not just this one, that a little bit of money invested in getting things right at the start can save an enormous amount of cost and heartache and difficult disagreements down the line. And so I really do think it's, firstly, a stitch in time saves 9 when it comes to legal support. Secondly, I think it also, probably not secondly, maybe even this is the first point, it gives your clients and your customers, I think, a degree of confidence in the fact that you're running a professional operation. So it can feel a little daunting to start a new commercial relationship or business relationship by presenting someone with a contract, and people often feel worried that doing that sets the wrong tone. But I think my experience is that people take a huge amount of reassurance from that, because it tells them that you have thought about the things that can go wrong. You have thought about the things that you need to set expectations on up front, and it can reassure them that you're running things with a degree of professionalism, which is, you know, not common across the industry. So I think you should not feel afraid of starting off on that foot. It can also, as it says here, help preserve your income. So I'm sure, you know, many of you will have come across situations where people leave you in the lurch at the last minute, and a bit of a grey area about whether they have to pay you for what they've booked but cancelled last minute. We'll talk more about that later. If you have all of that clearly set out in a contract, that can, you know, stop you getting caught out when people do inevitably let you down. And it also means you've got a degree of security about your income going forward. So for example, if you've got a contract where somebody's booked a block of lessons, or a contract where they're committed to staying with you as a livery for a certain period of time, it means you've got certainty that you've got, you know, sight of your income for a period of time going forward, and that can help with business planning and various other things. I think it also sets out it sets your relationship on the right footing with a new customer or a new client. And by that I mean you don't have sort of awkward conversations down the line where you've had a mismatch of expectations about what the operating hours are for a yard, or whether it's acceptable for parents to drop their children and leave them with you for 6 hours in the hope that you'll provide childcare after their lessons, or you deal with all of those things up front. It stops you having difficult conversations a little bit further down the line. It also helps to balance risk, and that's such a lawyer's phrase, isn't it? Balancing the allocation of risk. But really, that's what we lawyers do. It's about, in any commercial arrangement, there are various risks, and setting out really clearly up front who's expected to take that risk, who's on the hook if certain things go wrong, means everybody's really clear on the basis in which they're operating going forward. And we have on the last bullet that it's a pathway for resolving disputes. I would also add to that, it's a pathway for avoiding disputes. I think all too often people fall out at the end of a commercial relationship because something comes up that you haven't thought of at the beginning, that you haven't thought to set out clearly how you're going to deal with an issue that comes up. And, you know, when things are a little bit difficult, things are a bit fractious, there's significant cost involved, it can lead to a falling out that could so easily be avoided if you had just started out by, you know, thinking things through, having a bit of advice on, well, how will you manage this situation if this arises, or we have seen other people dealing with this, what's your expectation of how that will be handled? Spending a little bit of time getting clear in your mind how you would expect to deal with that as a business owner, and how you would want your customers to respond to those particular situations, can avoid you having to try and sort of, you know, make it up, figure it out when stuff's going wrong in a tricky situation, which is not the best time to be trying to work that out. So I would say, you know, we completely understand that it feels like a slightly daunting thing to be seeking legal advice. It sounds like you're probably putting yourself on a defensive foot, or sort of gearing up for an argument. But actually, as Jodie said, we very much see ourselves as trying to avoid that happening, and trying to give everybody the reassurance that if you spend a little bit of time getting the basics right and documented and established clearly, you can actually sleep better at night, because you know you've got sort of the back door covered, the things that can go wrong have been thought out and dealt with, but also avoids an awful lot of heartache and cost down the line. And you know, really can't stress enough, if you think legal advice on setting up is expensive, you should, you know, see the cost of disputes. I think they are, you could easily spend sort of 10 to 15 times unraveling an issue that you would have spent sort of preventing it in the first place. And so that would be my pitch for why it's worth investing in getting your basics right up front.
No, totally. Thank you, Laura. That's really, really helpful. And it is just that, you know, it's allowing, you know, when relationships do break down and people stop talking, at least if you can have a pathway to keep everyone talking and a way to deal with things, then actually you'll find that you don't end up spending a fortune in litigation, because litigation is terrifyingly expensive. Anyway, moving on to, so what would these documents look like? Now, for me, for a riding school, the first thing I'd be looking at, if I sort of came in and said, okay, right, how does your business work? Talk to me, how does your business work, and how are we going to help you with this? The very first thing, and probably the most important document of all, would be your terms and conditions of booking. Because presumably your business is based on people coming and booking lessons on repeat. And so every time a lesson is booked, that you are creating a contract. You effectively have, in legalese terms, sorry, but you have an offer, you know, I will teach you, and you have acceptance, yes, please. You have consideration, that'll be, you know, sort of whatever the price is. And then you perform the contract, you teach the person on a horse, and you provide those services. So that is a contract. And that contract, it doesn't matter whether or not someone signed a piece of paper for that contract to exist, it exists. Now, what matters is, you know, if you don't have any piece of paper signed, then the contract becomes effectively whatever either party, should there be a dispute, what the contract becomes whatever either party thinks it might be. So you end up with disputes where, you know, you have evidence from WhatsApp conversations, from emails, from overheard conversations, from diary entries, and all of this amalgamation is all about, you know, this sort of contract, this what are we getting and what are we giving in return. However, a nice way to avoid, if you know, should there be any dispute or any issue, and again, you know, we're lawyers, we're harbingers of doom, so we do talk about disputes because the idea is we try and keep you out of them. And the best way I've come across to keep you out of disputes, particularly with you know, sort of what you do, providing people with horses to go and have running lessons on, is to have a really good set of terms and conditions in place. And these should be agreed to, whether it's just by ticking a box or whatever it might be, every time someone has a lesson, or every time someone books a block of lessons, or it depends a little bit how your booking structure works, but this is what you need. This is the document that governs really the security of your business. It's not, you know, you probably think, oh gosh, you know, it's fine because I Googled one and ChatGPT came up with T's and C's of business, and then we put riding school in, and then ChatGPT came up with a few other things, and then we were sorted. Please don't. Please don't. I've unraveled a few ChatGPTs recently, and I'm always scared by the power of AI, and in this case, scared by the inaccuracy. You do need a proper contract which actually deserves some thought, because you're dealing as businesses to consumers, and you're dealing as businesses to consumers, and a lot of your consumers, your clientele, are also the responsible adults for children. So by its very nature, you need to be quite careful to ensure this terms and conditions is actually correctly drafted and carefully drafted. The law is quite different in the way it treats business to business transactions as opposed to business to consumer. Effectively, when you're selling a riding lesson, it's a little bit, in the law terms, it's a little bit the same as selling a washing machine or selling like a service package on a mobile phone. It's not, they don't know that horses kind of breathe and smell and eat and, you know, escape occasionally and stuff. It's the same concept. So you have to think about your business not in terms of as a horsey person in terms of how it works in equestrianism, but actually how would your business and how would your terms and conditions stack up if you were selling a mobile phone service contract, or a boiler service contract instead, or a boiler part, whatever it might be. So it's quite important that you get the structure right, and then equally that has ramifications and implications for what your contract actually holds within it. When you're a business to consumer, and it's presupposed these are fairly standard terms and conditions which aren't redone, sort of each deal to transaction, then actually you need to make sure these terms are, while you're obviously going to want to prepare something which is favorable to you, you can't prepare something which is unreasonably, disproportionately favorable to you. It has to be something which is genuinely reasonable. Otherwise, you run the risk of terms being struck out. So you can't say, for instance, exclude all risk, because that's not acceptable. You can't exclude all liability for death and personal injury, because the law won't allow you to do that. And if you try and do that, that will be struck out and your contract itself will become weaker. So, key contractual terms that we'd often see and that I would look for if I'm reading a set of these would be, the biggest one is limitation of liability. Now, bear in mind, you do need to be reasonable with it, but I would expect there to be a cap on total liability, which would be probably governed by your insurance premiums, governed by your insurance level that you hold, but also that we'd exclude any losses which aren't direct. So that means that, sort of if there is a claim, heaven forbid someone falls off and hurts themselves, then, there might be direct losses, which you might deal with, such as, you know, sort of I work as a tree surgeon, I can't climb my tree, which you would then pass to your insurance company to deal with on a personal injury basis. But what you wouldn't deal with is what you try to exclude is indirect losses. So I'm a tree surgeon, I climb trees, and next week I'm due to fly to climb the biggest tree in the world, and this is going to be the pinnacle of my career. And if I can't go and do that because I fell off and hurt my leg at your lesson, then I've lost the income from potentially this tree climbing situation, and so on and so forth. So what we do in the limitation of liability is literally that, close down the liability to actual direct losses. So you make sure that you're not responsible for stuff going on which is not immediately foreseeable based on your interaction with that client. Payment terms are the absolutely key ones. So you make sure that within your terms and conditions, you state that whatever your payment terms are, they need to be stated. You also need an interest provision. So if they're not paid properly, you will get the right to charge interest. You also need a no set-off provision. So that basically says that if there is any amount in dispute, or if you think they owe you money and they believe that you owe them money, that you should be paid in full. And then you deal with any kind of, you know, well, actually you might owe them something, etc., and so on. So it's really, really important that you have clear payment terms. I'd also always include in there on a payment term basis an automatic sort of annual, build in a right that every year you will review your costs, and there will be upward revisions. Within your T's and C's, I'd also expect an acknowledgement of risk. You know, working with horses, animals, large half-ton of horses is, you know, not without risk. And I'd also expect a statement of regulatory compliance from your side. So that would be, for instance, we are an ABRS affiliated riding school. We hold this qualification. All our instructors hold this qualification. So really just reiterating from both sides, you know, what the contractual balance is. The insurance requirements, I would imagine, should be in there. I would, you know, sort of be clear that while you hold insurance up to a point, you expect, you know, I would include in a drafting that, you know, sort of you'd expect clients to hold their own personal medical, private medical insurance. You know, and if not, they might be advised to seek some. Not that you expect them to fall off, but they are horses. And the other side of this that possibly hasn't really been thought about, and we'll touch on again later, is image release. So those of you who have, you know, the rise of social media, and, you know, people like using it and like seeing images and like seeing that people are out and about and enjoying the horses and enjoying the facilities, that's all fine and good, but I would stick in my standard T's and C's and image release. So if you take a photo that, you know, sort of shows a client having a nice time on a jolly hack, or having a nice time riding a horse in the school, or having a nice coffee, whatever it might be, that you've actually got a standard image release so that you have a right to publish that image on your social media to advertise your business should you wish to. And again, easily overlooked, but well worth thinking about. So with your T's and C's, we then look at the other really important part, which is cancellation rights. Now, as we discussed just now, you know, you're dealing with consumers, not businesses. So the cancellation rights are governed by a sort of very specific set of regulations. And what your cancellation rights should be are governed also by how the booking is made. So at law, there is a different treatment. If you're booking directly, you know, someone's walked into the tack room after the lesson and said, loved it, brilliant, sign me up, I want another 10. That has a different cancellation right applied to it than, for instance, a distance contract. And by a distance contract, you mean anything. If you're signing up online, you're booking your lessons online. If you're booking your lessons over the phone, that has a different treatment at law to the one where they walk into the tack room and sit there and say, this is what I want to do. Now, whether you choose to sort of try and differentiate between different methods of booking is really up to you. The key part is this cooling off period, and I'm sure you've heard of it again with purchases. So, you know, you've bought your washing machine and you don't like it, and you've got a 14-day period whereby you can send something back. Or the bigger ones are the mobile phone contracts, aren't they? It's effectively, you have this sort of cooling off period before you've really used anything or really done anything. You can opt to send something back if you're not using it. And the same, again, applies to this situation. It's not perfect because it wasn't designed with riding lessons in mind, but it is the law and we do have to respect it. Now, how you know, the law would state that you have to offer a calling off period for any contract which is not concluded directly in person. But whether from your business perspective, it's actually even feasible to have some lesson booking mechanisms whereby you have no calling off and some way you do, I don't know. That will depend and change business to business. But I think the important part is that you have a policy, that it complies with the applicable law. And I would also always remind people of it at the point of sale. So, whether it be, sort of, you mention it in your booking, whether it's when you get an email confirmation, there's a 3-liner which refers you back to your terms and conditions saying, if you cancel after this period, you will be charged in full, whatever it is. The best way you can really protect yourself and also ensure that these rights are enforceable is always to make sure that it's very, very visible to your clients, because when you're dealing with consumers, the law expects you to make it easy for them to understand. They don't expect you to sort of bury it in the black type at the bottom of the page and 18 pages in. They expect you to make it clear and upfront. Disclaimers. Okay, I promise you'll get bored of me soon. This is the other part that I would expect all riding schools to have, and whether you build it into your terms and conditions or whether you have it as a separate type of and you can Google disclaimer and get some absolutely marvelous things. But for a disclaimer to be actually effective, it actually needs to be quite specifically drafted. So you can't just sort of download the closest, nearest, the one of the riding school down the road and nick it. It just doesn't quite work. You should make sure that your disclaimer talks about at the beginning the different types of activity that it's being drafted for. So where I ran a yard that we had a canter track. We had a canter track and we had an outdoor arena with jumps and we had an indoor arena with jumps. Now, within that disclaimer, we referred to the canter track, which was partially unfenced. We referred, and in fact, it had a footpath going next to it. So we made it absolutely clear at the front of the disclaimer that, this canter track is used at your own use. You check the footing, you check the holes, and you're warned that there's a footpath running next to it. So, sort of you're all pre-warned of these things. Now, every single facility will have different danger areas, things to consider in respect of where possible danger or possible issues might arise from for their facility. I had one facility which had a set of cross-country schooling where one loop went along a road, which was a busy A road. And so again, we put into the disclaimer, please note that there is an A road on this side, so you may wish to act accordingly. But the point is that you should really be thinking about your program, what you do. Do you offer off-horse lessons, things like unmounted grooming, tying up, that kind of thing? Again, that should be referred to as, sort of this covers all actions, whether you're on the horse or off the horse. You want to ensure that disclaimer disclaims all appropriate things, but obviously we can't disclaim for personal injury and death due to negligence. That can't be disclaimed for anywhere. But the responsibility really for a disclaimer should hinge back onto the rider or the responsible adult. And for those of you that hire facilities out, we've also done disclaimers whereby we expect any incoming instructors to hold a minimum level of insurance, and also that those instructors are also responsible for checking footing and checking facilities before they go. So really you're pushing that responsibility on them. And then I would also include a damages clause in your disclaimer that, if anyone breaks anything, that you can invoice them, and also make sure you get their name and address and contact details up front so that you've got all of that. So, there's no point having a disclaimer that says, yes, I can invoice if there's broken poles, and you go to invoice and you've got, sort of A, B, someone at Diddley Squat Farm, and you're like, well, that's definitely not Jeremy Clarkson. So, we're not really sure who this is. You need to make sure you've got valid details so that you know who you're talking to and who you're potentially invoicing if there is any damage. And again, we just spoke briefly about image rights, and one that's again sort of has come to light and been more and more prevalent is that, sort of what happens if people are sat videoing and it's a lesson where something goes wrong. and there's actually, you know, sort of say there is a problem or a fall or whatever it might be. And then within the disclaimer, I've also drafted them for clients whereby we've actually put in a clause where we've said that, you know, if you are videoing the lesson and there is an incident, that we want to see a copy of that footage, and we expect it not to be shared publicly, you know, in the event of any accident or danger, because really it's about your insurance company and you being able to look at it and review it properly. And that's not always going to happen if it's found its way to the court of Facebook and social media in the interim. But again, you know, sort of when we're looking at all this, it's really every client has a slightly different perspective in terms of what they're concerned about. So really it's our job as lawyers to understand what your key issues are and really try and advise around them. But these are all just various options and things that we have done in the past, and things that we, you know, sort of would advise you to think about when you're looking at your business. Laura, I will pass to you for livery arrangements.
Thank you. So many of the same themes, I think, will arise here. And, you know, as Jodie says, there's a lot that you can find online. And I will say on livery agreements that there are some pretty good templates available online. But I would also say there are lots of things not covered in the templates you can get online that, you know, certainly experiences that I've lived through or things that people might not have thought of. So again, as with the sort of riding lessons and things, presenting your new clients when they come in with a livery contract is not a difficult or awkward or uncomfortable thing to do. Presents you as being a very professional organisation and gives you an opportunity to really set out expectations about how things will run. And it can be anything from, you know, the rhythm of the yard, for example. Are there particular times where you wouldn't want your liveries coming on the yard? Or, you know, if you live on site, do you not want people crawling around at 10 o'clock at night? Do you not want them setting off the alarms at 6 o'clock in the morning? It can be from the very basic practical arrangements about how you will operate together as a livery to the more thorny legal issues. And so I think it is worth spending a bit of time and thought in putting together a comprehensive template legal agreement, livery agreement, that you give to your liveries before they arrive. And I would strongly recommend that you don't let them come until they've signed in, because I know from experience that once people have got their horse on the yard and they're all settled and it's all going well, it's really difficult to then get a signature from them on the piece of paper. At having sort of bespoke agreements depending on the type of livery, so that sets out clearly what services you're on the hook to provide and what services you would expect, or what sort of things you would expect your liveries to be doing for themselves. Paddock poo picking is always my thorny one, because I feel like that's the thing that everybody ignores and hopes that someone else is going to do. But that's just one example. I think Jodie's touched on insurance. That's another key one. I've certainly come across situations where, you know, we all hope it doesn't happen, but we know that tack room break-ins and thefts are really rife, and suddenly everybody assumes that somebody else's insurance contract is going to cover the tack that went missing. I think lots of people aren't aware that as a livery owner, as a yard owner, you're not able to insure property that belongs to other people. You can only insure property that you've got an insurable interest in. And that means that however good and robust your insurance policies are, it won't cover other people's tack and horses. And making that really clear to your liveries in advance when they arrive, so they know that it's their responsibility to insure their horse and their property if they want to, it's their choice, but it's their responsibility. Can avoid some difficult conversations if things do go missing down the line. I also have in my livery agreements an obligation on owners to have a minimum level of public liability insurance. So, for example, you know, difficulties can arise if you've got, you know, member of staff turning a livery horse out in the field, something spooks the horse and your member of staff gets kicked. You know, if the horse owner doesn't have a level of public liability liability, then that's going to be sort of coming against you as an employer, against your employer's liability. And just always worth making sure that your liveries have got their own public liability policy. And actually memberships of British Eventing, BHS, all of those professional bodies, that comes as standard, so it's not a particularly onerous requirement. Already touched on yard rules. I think another thing that nobody particularly wants to think about, and when it happens you really wish you had thought about it in advance, is what happens in the awful situation that you've got a livery horse, you go out in the yard in the morning and it's colicking badly, or it's, you know, you've got one leg hanging off in the field, and the owner is the middle of school run and they've got no phone signal, or they've got, you know, busy day at work and you can't get hold of them, and vet, you know, you need to call a vet, but you're uncomfortable doing that in case they're cross with you for incurring a vet's bill that they didn't want. So I think setting that out clearly in your contract can make a really stressful situation mildly less stressful if you know you've got their permission to contact their vet, who their preferred vet is. And although it's really a situation none of us want to be in, to set out clearly in your contract, for example, that if a vet advises that a horse needs to be put down in its own interest, it can't be saved, and it's the kind thing to do and it needs to be done quickly, and you can't get hold of the livery client, that you have permission to do that. And Jodie says we are awful doom mongers, we lawyers, and we spend our lives thinking about sort of the worst things that can possibly happen and how we would deal with that if it happens, and that's not a situation anybody would want to be in. But if, heaven forbid, you were in that situation, the last thing you'd then want is to have a livery client coming after you and saying you didn't have the right to do that and you need to go and buy me a new horse. So things like that are difficult conversations to have, but much easier conversations to have up front when you can clearly set expectations. And for example, I've had a livery who quite validly has said, well, hang on, no, you need to not just try and call me, but if you can't get me, call my partner, call my parents. I've had sort of 3 lines of, if you can't get hold of any of these people and you really have to make the decision, then fine, you make the decision. But these are the people that you contact before you spend any money on my behalf or have to make any difficult decisions for me. Payment obligations are a key one. I always recommend getting paid upfront for the month ahead. But I'm sure we've all heard of or probably even experienced the liveries that pack up their lorry in the middle of the night and disappear, or tell you they're going to a show and never come back again and leave a bill unpaid. If you've got a very clear payment obligation in your contract and they've not met it, then it is much easier for you to enforce that. And, whilst Jodie and I have frightened you a little bit about how expensive litigation is, it's actually not that expensive or difficult to enforce a clear contractual obligation to pay. So if you've got very clearly set out in your livery agreement, you must pay me this much a month. And if you want to terminate this agreement, you've got to give me a month's notice or 3 months' notice. Then if they don't pay, you've got a very clear and enforceable contractual obligation that you can go online. So the government have made their sort of access to the court system very easy now for lay people who are not lawyers, and it doesn't cost very much to go and enforce that and get a judgment against them. Whereas if you've not set it out and you haven't got a contract, then you are in dispute territory, you're relying on lawyers, and the reality is you're unlikely to get that money back because the amount you'd spend in litigation far exceeds the amount that you'd be trying to claim. Termination rights at the same point, so on how much notice they've got to give you to leave, and Jodie's put this on the slide, and absolutely right and sensible to bake in an annual fee increase. I certainly in my first few years of operating a livery business got caught out by inflation gradually creeping up and realizing that everything was an awful lot more expensive and my livery prices haven't caught up with it, then it becomes a really difficult conversation to have with people. Whereas if you just set out at the outset on the 1st of January or 1st of April, all our prices will go up by X%, then that happens automatically and you don't find yourself sort of chasing to catch up with the inflation that's been creeping up on you over time. So again, they're not difficult, they're not particularly sort of expensive things from a legal perspective to have some help with, but spending a bit of time just thinking about how you deal with all of those arrangements, getting it all clearly written down so that you will start your new commercial arrangement with clarity on how you're going to deal with things can really save you an awful lot of time down the line. And particularly on that point about sort of enforcing notice periods and enforcing unpaid bills, it is just super quick and easy to do that if you've got a proper contract, and really difficult to do that if you haven't.
Thank you.
Right.
I think that is the thing, isn't it? That it does matter, and having the correct contract, making sure you have a good contract means also you have the right contact details for people. And then suddenly, if you have the contract and the contact details and a residential address, then actually the money claims online system is not difficult to use, and you can use it for claims up to £10,000. But the first thing money claims will ask you for once you've sort of registered is what is the contractual document, and the first thing you'll be giving them is a copy of the contract and a copy of your invoices. So this takes away all of that drama from you. Employment contracts were the next area that we were going to touch on, noting that we're not employment specialists, but these are things that we think are really important you guys are aware of and thinking about at this point.
Yeah, so this one's also me, I think. So just a few things to think about here. An employment contract doesn't need to be hugely formal and detailed, but does absolutely need to be written down. And it is a legal requirement that if you have an employee starting, you have to give them a basic written statement of the kind of core terms and conditions of their employment on the day, on or before the day that they start. And it's fine if you then follow up with something more detailed. You know, if things are happening quickly, you want to follow up with something more detailed later on, that's okay. But it is a legal requirement to have certain basic provisions covered in a day one statement. And that includes things like hours of work, place of work, entitlement to lunch breaks, when they will get paid. There are lots of sort of formalities about that. And I would also really strongly recommend including in that your health and safety policy. It's really easy to think that that's something that's going to be dealt with on day 2 or a little bit further down the line, but it's such an important thing, particularly in, you know, the more risky environments that we operate in on yards with horses, to have some basic health and safety policies and procedures set out really clearly, you know, so that there can't be any argument about whether you'd explain to somebody the importance of wearing a hat if they're handling the baby horses, or what your yard rules are. It's really common in our industry to rely on freelance workers. I do it myself. And I think there is a perception that if somebody calls themselves a freelance worker, then they're a freelance worker. And unfortunately, that's not the case. Freelance work has its place. It's a really useful, flexible tool for both an employer and an employee. But HMRC, the tax authorities, are very good now at seeing through where people try and sort of hide behind the label of freelance to avoid having to pay income tax, PAYE, national insurance contributions. And so the tax authorities now operate as a sort of substance over form approach to this. If somebody walks like a duck and quacks like a duck, they're going to probably conclude that they're a duck from a tax perspective. And you may find that if you've relied on a freelance worker who has set days, who turns up the same day every week, who works, you know, very consistent hours every week, who doesn't have multiple employers for whom you might be their only source of income, even if they're not full-time, that could only be 2 or 3 days a week, then the likelihood is the tax authorities would consider that they are an employee, even if they don't have a contract of employment, and that you might find yourself responsible for retrospective PAYE tax contributions or national insurance contributions on that, which can be really, you know, really expensive, because if you've agreed an hourly rate with your freelancer on the assumption that they're responsible for sorting out their own taxes, and then HMRC says, oh, actually, we don't agree. We think that you had an additional, effectively, kind of 20% liability that you need to pay to us directly on top of that, then you don't have any recourse to reclaim that from the individual. So really important to be clear when you've got somebody who's an employee, and we can advise on that, but the key indicators are things like regular hours, regular days, reliance on you for income. And that's not to say that all freelancers are at risk of that, because there are some legitimate situations in which somebody would genuinely be a freelancer, but it's important to take care that you don't sort of sleepwalk into that. Minimum wage is another really difficult one in our industry, and Jodie and I have had many sort of fireside chats with our employment lawyers about how difficult it is to get it right in our industry, where the hours are long, where horses don't switch off at 5 o'clock and demand no attention until 9 o'clock the next morning, where you need people to be doing late checks, where a veterinary emergency might require that somebody stays up all through the night, or where somebody not turning up means the rest of the staff have got to work on their day off or step in. Then calculating whether you're paying the national minimum wage over a period of time, not necessarily sort of an hour by hour basis, is really difficult. But the consequences for not doing it are really serious. And again, there's been a real crackdown on that now, with a lot more naming and shaming of industries and named individuals in those industries who are not doing it. So worth just absolutely knowing kind of what your liabilities are for that, both in terms of minimum wage, but also time off, paid breaks, the sort of time off requirements for how much time people have to have off in between shifts and things is something to pay a bit of attention to. And I think something that we've, don't like to use the phrase got away with, but the industry has sort of flown a little bit under the radar for a long time on this, because everybody says, well, that's horses and things are different when it comes to horses. But I think there's a growing realization that that's not the case anymore, and that we need to pay more attention to that. And making sure that you've got clarity with your workforce about your employer's liability cover. So you do have to keep in regular communication with your insurers about the number of people that you're allowed to employ and how freelancers are treated under that, and making sure that freelancers are covered by your policy. It's all very well sort of assuming or expecting freelancers to have their own policy, but all too often that falls by the wayside and people don't think about it. So really important to make sure that you've got that in place as well. And again, your day one statement, whether it's for an employee or a freelancer, is a really important way of sort of documenting your expectation about whose insurance is covering their work, and you know, whose responsibility is to make sure that that's arranged. So again, that's a little bit of a frightening counter through all the things that can go wrong and all the people that can slap you on the wrist for getting that wrong, but really important to spend a bit of time getting that right on day one.
Thanks, Laura. Yeah, no, employment contract, it is such a thorny issue, isn't it? But there is increasingly more and more HMRC scrutiny. I think they published various lists of riders that were fined for very late PAYE contributions. And I think that was published earlier this year. But they're certainly looking at the sector more and looking at the industry more. Right, everyone can go to sleep for 5 minutes because I'm going to talk about business structures. I'll wake you up in 5 when Laura's going to do something way more exciting. But this is a bit of a personal, I suppose, crusade, maybe too much, I don't know. Okay, so I see a lot of businesses, and because like Laura, I work with a lot of outside of equestrian, I work with a lot of startups, and it makes total sense that, you know, when you're starting a business up and when you're getting off the floor and you're trying to work out if it's going to work, if people are going to come and use you, if people are going to, you know, sort of, if you're going to be busy, if it's going to turn into a proper business, that people start off their business as a sole trader. It's very easy, it's very kind of regulatory light. And you run it off your same bank account, and it's all just simple and makes sense. But it's really, really important that you then do, once your business is functioning and floating along, that you do take stock and consider how your business is best structured. I know that George and the ABRS have talked quite a lot about CICs, so I'm not going to cover CICs on this point, just on the basis that I think you have had quite a lot of information about them. But obviously it is a sensible way to go for a community interest organisation such as a riding school. But often a CIC, in the process of registering a CIC, takes time. And really, I think what I wanted to do is really dispel the myth that to have a limited company is both painfully expensive and an administrative sort of nightmare. It's not. And really, in terms of practical steps to register your own limited company, you really just need to find a sensible accountant. And there are accountants now, more and more, I'm finding, which specialise in rural affairs and specialise in equestrian affairs, who can advise you sensibly around things like both your payroll and your business structuring, and also in response with any VAT issues as your turnover sort of creeps towards the VAT threshold. But you know, the biggest reason why you would have a limited company is to ensure that you can protect your own personal assets. And again, I know with horses, you know, there's a thing, you know, sort of everything that the horse owns is theirs, and everything of yours is probably, you know, belongs to or mortgaged up to allow for the horse anyway. But actually, it's as a business, you are a commercial business like any other commercial business, and any commercial business, once they have achieved proof of concept, once they know that, you know, people are going to spend money with them, should be considering whether they set themselves up as a limited company, because the biggest issue is that the company has its own legal personality. Now, what that means is that it becomes its own contracting party. So when you sign your terms and conditions, when you sign an employment contract, when you sign the lease for the yard, you do it as the company. You don't do it in your own name, you do it as the company name. So Jodie Limited will have a share capital of, say, £100. Now, if Jodie Limited was to be sued by someone because there was, and Jodie Limited would have also her own insurance as well. If Jodie Limited was to be sued for some reason, then my liability as Jodie Limited is limited to the amount of money that sits in that business and that business's insurance. Now, what they can't do is then, or what I'm not putting at risk, is all of my personal assets. So effectively, by working as a limited company as opposed to working as a sole trader, when you're a sole trader, there is no line, there is no protection of your own personal assets when you're a sole trader. Whereas if you work on the basis of, you know, a company, and the company has its own legal personality, the maximum the company can be liable for is what the company has in it. And there are very, very limited circumstances, normally involving a criminal situation or fraud or misappropriation of funds, where you can, and the phrase is wonderfully legal, but it's called piercing the corporate veil, where they can look through a company and look to the directors and look to the directors' personal assets. But that's very, very limited and very unlikely to materialize in the event of the types of businesses you guys run, unless you're quietly money laundering on the side, in which case, you know, that goes with its own risk. But it's really, really important that you actually think about the fact that, you know, for the sake of working with an accountant to file proper accounts annually, they'll mostly work on a fixed fee basis with you. Then actually you're protecting your business, because your business then signs all the contracts. Then that business becomes a business that is signatory to all of these sort of various contracts of supply, various, you know, if you're working with schools, if you're working with, you know, sort of larger structures, again, you're working with the business, and so the business itself becomes worth something. But equally, you're not exposing yourself to significant losses. Now, you know, obviously when you start a company, everyone thinks, oh gosh, directors, you know, sort of to be a director, that's terribly, it's hard work and stressful. Well, it's not, because you're just running a business. And fundamentally there are various statutory obligations on directors. And again, your accountant or a good lawyer should be able to walk you through what they are. But effectively, if you are working in the best interests of the company and you take the company's best interests at heart, then you don't go too far wrong. So that's really sort of my pitch for why you should be looking at limited company structures. The other structure I often see, and we're working with more and more on a equine side and rural side, is partnerships. So often if you've got a property which is perhaps within the family, so perhaps, you know, sort of parents or grandparents bought a property and you're now operating a business using those facilities. I've worked with 2 or 3 tax advisors now, putting together structures where effectively we're using part of the assets of the property within the business, and thereby creating a more tax efficient structure when we're looking at, you know, sort of businesses that run on an intergenerational basis, provided that everyone is still involved in the business. So even if it's, you know, granddad doing the poo picking and a bit of arena harrowing, and actually, you know, sort of say for instance, mum is running a business and a daughter or son is perhaps competing and training and coaching people, that represents a multi-generational business, which if they're all doing it using the family farm, actually we can structure a situation so that the tax burden should the grandparents pass away is minimized. So that's also one worth thinking about if you're in the position where you are looking at a family farm or a family situation which is, you know, sort of developing. But that's my plea to business structures. Everyone can wake up now. Laura, do you want to talk us through a little bit about data management, which is way more sexy and interesting than structuring businesses?
Oh, well, I don't know. Yeah, happy to. So Jodie touched on this at the beginning, and I think, you know, GDPR, data protection, everybody's become a lot more aware of that in recent years. GDPR certainly sort of gave everybody a good wake-up call about this, and I think it's probably a lot more on people's radar than it would have been a few years ago. But nonetheless, it's still quite a scary, opaque thing, and difficult sometimes for people to understand exactly how it applies to them. So I think the first thing to say is that you will all be dealing with a huge amount of personal data. So whether it's the name of your clients, their telephone numbers, home addresses, payment details. So if you keep, you know, if you have an automated payment system and you keep bank details or credit card details online, any photographs or footage you collect during the course of lessons or via your CCTV cameras, if you've got security cameras, as I'm sure many of you have, plus any personal data that will be referenced if your instructors keep sort of notes of lessons afterwards, emergency contact details for next of kin, that sort of thing. All of that constitutes personal data, and you have a legal responsibility to take some steps to make sure that you're dealing with it appropriately, managing it, storing it securely, and crucially not keeping it for too long either, and only doing with it what you've sort of told your clients and your customers that you said you're going to do. And that's not only a legal obligation, but I think it's a really important commercial and relationship point as well. Everyone is a lot more savvy now about what's happening with their data, and it can generate an enormous amount of ill will, I think, if people feel that you're not respecting their personal data or managing it responsibly. Certainly in the case of riding schools where you're dealing with people's children. My own personal bugbear, and I think I'm in a small minority, is you know, clubs that willingly put photographs of my children on their Facebook page to use them as promotion without my permission. And I try not to be a sort of scary lawyer about it, but it drives me mad if I've not given consent for my children's photographs to be online and it appears on Facebook. That really irritates me and leaves with me a really sour taste about the sort of professionalism of the club that we're dealing with. So I think just to highlight a few key responsibilities is depending on the volume of data and our sort of, you know, again, as Jodie says, we don't give specific advice here, but our some working assumption is that for this group of people, you will probably all be dealing with the volume of data and the category of data that means it would be prudent to have a registration with the Information Commissioner. That's not difficult. It's an online form. You pay a relatively small fee to be registered as a data controller. And again, that's just one of those sort of steps of professionalism that gives your clients the reassurance that you've given some thought to those things. Then you need to have a person who is responsible for your data protection matters. So is responsible for keeping a register of the type of data you hold, your category of your list of categories of data, whether that be names, addresses, telephone numbers, or anything more sensitive. Particularly important if you're dealing with health data. So it's not uncommon. In fact, it's probably good practice to be asking people to disclose any particular medical conditions. That automatically puts you in the category of people that are dealing with sensitive personal data, because you've got data about people's health status, and that carries a more onerous requirement than the basics like name and address. So you need somebody whose responsibility it is to, first of all, just know what data you've got, to second, know where it is. So how is it organized? What systems do you keep it in? Who has access to those systems? Do you allow anybody that works at your riding school, from your kind of, you know, 14-year-old Saturday girls right through to the managers, to have access to that? Or do you limit access to that to certain categories of people? If people ask you for your data privacy policy or notice, can you easily provide that? Is it available on your website? Do you make it available to people when they sign up, when they make their first booking and give you lessons? And then secondly, to think about how long you reasonably need to keep data for. And for different categories of data, there are different rules about how long you firstly must keep it for. You have to keep certain data for compliance purposes. But then secondly, making sure that you don't keep it for too long. So if it's not data you have to keep for regulatory compliance, or because they're ongoing customers, you know, for example, if you've got a client who's not visited you for a couple of years, is it reasonable then to then think, well, they've probably moved away, or it's, you know, we ought to be deleting their data now, so we're not keeping it for too long. I'd also say that while taking the time to go through your records and sort of expunge and purge data seems onerous, it can actually save you a bit of trouble down the line. You know, riding schools are not typically the sort of business that are going to get bombarded with data subject access requests, but if that does happen, it's hugely onerous to start going through all of your records and pulling out all of the information you hold on a person, and you are legally obliged to hand it over to them if they ask you to. But if you have deleted it in accordance with your data retention policy, then you're exempt from that requirement. So if, for example, you've got a data subject access request and you've not in recent years had a sort of a purge of expunged data that you don't need to hold anymore, you're obliged to deliver it up. But if your data retention policy says, well, actually, we delete data from anybody that's not ridden with us for 2 years, and you can demonstrate that you've done that in compliance with your policy, then you don't then have any sort of additional obligations to respond to those requests. So again, probably not the most exciting thing. It's a little bit onerous, but once you get into the rhythm of it, it's not that complicated. And it's another situation where just having kind of good hygiene practices can avoid you tripping into trouble down the line.
Thanks, Laura. I think that's all we had for you. I think we were planning, and with George's thoughts to give you a sort of hours, I suppose, canter through of key issues, and I think we've pretty much nailed it on the timing. So thanks, Laura, thanks everyone. And really, I need to reiterate that, you know, we are here. We're not scary people who live in suits and clatter around in high heels. I'm definitely wearing breeches still, and you know, sort of, we are very much, we understand the nature of the business that you work in and the nature of the world that you guys work in. So we're very much available to you know, take any inquiries and have an initial chat to work out whether you need our help or not. But you know, please do feel free to sort of use us, and our contact details are there.
you very much.